The Enforcement Directorate is one of the most dreaded institutions in this nation. Due to the recent chain of events, it is important for us to understand what is the Enforcement Directorate and what are the recent chain of events. Why did it issue a summon for the CM of Delhi? And he chose to skip it. But what is next? From the perspective of GS Mains Paper 2nd, it is important that we understand it. Also from the perspective of GS Mains Paper 3rd, because this is a law enforcement agency which is concerned with economic offences. Alright, so the recent chain of events go back to the liquor policy case, the liquor policy scam. I have already covered that in detail. I will provide the link of it in the description box. You can watch that. So under the liquor policy scam, it was an alleged economic offence, and many important ministers of the AAP were summoned by the CBI and the Enforcement Directorate. Certain ministers such as Manish Sisodia and Sanjay Singh have already been taken into custody. Manish Sisodia also applied for bail, but that couldn't go through in the Apex Court. The issue with respect to bail when it comes to the Prevention of Money Laundering Act, this is one of the most dreaded facets of the Enforcement Directorate. I will tell you about it. So the CM of Delhi was issued a summon by the Enforcement Directorate, but the CM chose to skip it. This was a serious summon, and before the particular date of 2nd of November, he was supposed to appear in front of the ED on 2nd of November. Many ministers through a press conference of the AAP said that there are apprehensions that the CM may be arrested on 2nd of November, but now he has chosen to skip it. What is the Enforcement Directorate and what are the powers of it? Also, what happens if one doesn't abide by the summon of the ED? What can the ED do for CM Kejriwal now? We will get into that. So these many things have to be covered. If we talk about the Enforcement Directorate, it's a law enforcing agency and it regulates the working of the economic affairs in the country. That means it comes under the Ministry of Finance and the Department of Revenue. Sometimes UPSC prelims can also ask us certain questions that it comes under the Ministry of Home Affairs. It comes under the Department of Revenue of the Ministry of Finance. Alright, and it works to counter economic crime. Any crime that is with respect to money laundering or any economic crime, that is dealt by it. It is headquartered at New Delhi, but it has 5 branches in Mumbai, Chennai, Kolkata, Chandigarh and in Delhi as well. Zonal offices are all across India. It does investigation on frauds and money laundering. It was established in the year 1956 as an economic unit. And back then it was formulated in order to see that if there are any violences for the Foreign Exchange Regulation Act 1947. But it was revamped when the Prevention of Money Laundering Act came into existence in 2005. Now it enforces specifically 3 acts: the Prevention of Money Laundering Act, Foreign Exchange Management Act of 1999 and the Fugitive Economic Offenders Act of 2018. Now, what about the money laundering? What is money laundering as it is defined by the Prevention of Money Laundering Act? Money laundering basically means if one is concealing, hiding, is in possession of any proceeds through an economic crime, that can be suggested as a money laundering. And it can be for those people who are doing it even knowingly. They are assisting it, not actually doing it, but they are assisting some person in order to do that. If they are directly attempting or even indirectly attempting any of these actions, then also the Enforcement Directorate can have an eye on them. The current situation is such, under which section of the which act the CM has been summoned? Section 50 of the Prevention of Money Laundering Act, not any scheduled act, but a Money Laundering Act of 2002. Anyone who is summoned shall be bound to attend in person or through authorized agent. They shall be bound to tell the truthful statements when they are asked to do so, or make statements and produce such documents as may be required by the Enforcement Directorate. Basically, under this section, the person has to come to the ED and give statements which are truthful as according to the act and the investigation, and if they have to provide documents, they will do so. So this is a really powerful section of the PMLA, as you can see, section 50. Now it goes back to pretty, we can call it 2022. 2022 was the time when the preliminary complaint, which is equivalent to a charge sheet, it was filed by the ED in a Delhi High Court. And CM Kejriwal, according to this charge sheet, allegedly spoke in a video call with one of the accused, with the main accused actually, who was Samir Mahindra. And in this video call, the CM told Samir Mahindra to continue working with Vijay Nair, who is a co-accused. He was Aam Aadmi Party's communication in charge back then, and telling them that Vijay Nair, according to the allegations, CM said that Vijay Nair is his boy. And Vijay Nair has also allegedly said that the liquor policy was the brainchild of CM Kejriwal. And liquor policy scam has been thoroughly covered by me. Do watch that. It's very important for you to understand that scam. It was a corona period policy, but which was rolled back later on. Now, if you want the PDF of whatever classes I take here, you can be a subscriber to my Telegram channel, Pooja Dwivedi UPSC. Any queries, and if you have any queries or situations, you can talk to me on my Instagram as well. I have to continue this forward as well. We have many slides to cover, but let me tell you about the P2I batches, which are going to be launched on 17th November, 15th November and 10th November. From 10th November, we will have Hindi batches, from 15th English, and English will be from 17th November. These are evening classes, 6 p.m. The P2I batches will make you very confident, not only for prelims and mains, but also the interviews. Many coachings differentiate between GS batches, then we have CSAT batches, we have separate batch for essay ethics, but we do not do that. It's a holistic batch. Not only you will be prepared for prelims, mains, interviews in the form of GS, but also CSAT, ethics, essay, language papers will be also discussed. We will also provide you prelims test series, mains test series, daily answer writing practice, everything is there. Make sure you use the code whenever you are going to take admission. These will be live batches. That means you will be able to interact with the teachers. And the cost is 26,999, which is pretty low. Alright, let's move forward. Now, if we talk about Section 19 of the PML Act, we are going to discuss that under it only the ED has passed to arrest a person. For example, the ED's director, deputy director, assistant director, or any other officer who is authorized by the union government can arrest a person if they are having apprehensions about them. Now, what do we need? What kind of materials or what kind of evidence do we need to arrest any person according to the ED? Materials in their possession, that means if they see that the person is possessing something which may be a ground for arrest, and also written reason that led them to believe that the accused is guilty. Now, materials possessed could also be the materials that are in possession of the ED. Okay, if they are having enough evidence that these are the kind of materials that are going to show us that this person may be an offender or any reason, then of course they can be accused, okay, as a guilty person and hence arrested. Then the arrested person is required to be produced by the special court or the magistrate. The ED may seek the accused's custody or urge the court to detain the accused in jail custody, that means jail as well. Judicial custody, that means jail as well. Offences which are punishable with imprisonment of 7 years up to 7 years or lesser, then Section 41A of the CRPC will come into existence. That means this will be followed, and the Supreme Court's directions require the investigation agency to issue a notice to the accused, so that this power, which is very wide in nature, cannot be abused. It directs the appearance for interrogation instead of arresting them straight away. So this is in order to secure the vulnerabilities. The citizens of India are not very vulnerable to this situation that the ED has actually put out in front of them. The restrictions on the court's power to grant bail is one of the most important issues. If for scheduled offences under the issues with the ED, if the ED is going to arrest any person under scheduled offences, then bail can be granted. But when it comes to prevention of money laundering, getting bail is really hard. So this is one of the most, you can say, dreaded parts or most feared parts of the ED. And they cannot be released on bail in money laundering case. This is something that every person right now is dreading for CM Kejriwal. Now, this started to be seen as unconstitutional by the apex court. That bail can't be granted, this is like an infringement of freedom. But the union government brought Finance Act 2018 and the same was upheld by the Supreme Court in 2022. Now, even if there is no kind of fear that the person who is accused will run away or abscond if they are going to tamper the evidence or influence the decision in some kind of way, influence the whistleblowers in some kind of way, then also the court may refuse to grant bail. The court refuses to grant bail when there is a fear that this person might run away, when there is a fear that this person is going to tamper with the evidence. Even if these fears do not exist, then the court may refuse to grant bail and authorize pre-trial detention, that before trial we can detain that person. If we talk about important cases, then Vijay Madan Lal Chaudhary's case of 2022, here the Supreme Court said that ED is under no obligation to put the enforcement case information report or share the enforcement case information report with the accused, because it is not an equivalent of the FIR and it is an internal document of the ED. This is what the Supreme Court has said. And it is sufficient if the ED merely informs that the accused about the reasons for arresting them. It is not necessary that they are going to give the report to the accused. This is what the Supreme Court has said in the Vijay Madan Lal Chaudhary case. Also, ED officers are not police officers. For the purpose of protection from self-incrimination as enshrined in Article 20, Clause 3 of the Constitution. Self-incrimination is generally self-exposing. If I say that yes, I have done this, what you are accusing me of, this is self-incrimination. There is a regulation for self-incrimination when it comes to police officers, so that the police officers do not force any person to give evidence against them. But it is not for the Enforcement Directorate officers. So this is something that is another dreaded part. First is bail, and second, these kind of very wide-ranging bans or very wide-ranging kind of prohibition that is provided on the ED. Okay, moving on. Now, what will the ED do? Let's talk about that. ED has given a summon. It was skipped. Again, ED can continue to provide notices of summon to the Chief Minister of Delhi until and unless he comes for the investigation to their office. But they can also move if it is beyond their capacity to call him. It is also possible that the ED can move an application before the concerned court and get a non-bailable warrant against him. Also, they can show up at his residence and question him there. And if necessary, if there are concrete evidences, then he can be arrested as well. If he gets arrested, then he will be the second CM in India to be arrested. First was, tell me in the comment segment. I have completely made you understand that in one of my classes. Thank you so much for watching. Stay updated.